How's it going, everybody? This is Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention the filing of an important brief by FPC in the case of Cargill v. Garland, currently before the Fifth Circuit Court of Appeals. Prior to the tragic events in Las Vegas on October 1st of 2017, very few people in the US, especially those outside of the firearms community, knew about or had heard of bump stocks. However, after those events, bump stocks became the crux of public discussion, resulting in Congress considering and ultimately denying a ban on the devices. For many years, the ATF had correctly concluded, as any rational person would, that the NFA and GCA, which define the term machine gun, does not include devices like bump stocks. The ATF, after being ordered by former President Donald Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would subsequently be considered to be machine guns. This new rule took effect on March 26th of 2019. Therefore, owners were required to either destroy the devices or surrender them at the ATF office prior to the effective date of the rule. From 2010 to 2018, the ATF estimated as many as 520,000 bump stocks were sold with a range of prices between $179 all the way up to $425. In total, the new rule resulted in the destruction or surrender of devices with a combined value of over $102.5 million. This regulatory change made possessors of bump stocks subject to a punishment of 10 years in prison and or a fine of up to $250,000 if they failed to destroy or surrender a device that the government had expressly told them prior was legal. The plaintiff in this case, Michael Cargill, is one of those people. Mr. Cargill is a gun shop owner, an Army veteran, and also a firearms instructor in Austin, Texas. He had bought two bump stocks in April of 2018 with the understanding, like many at the time had, that possessing a bump stock was legal. In fact, an ATF approval letter included with his devices indicated as much. However, because of the ATF's new regulatory definition, he was forced to surrender his bump stocks to the ATF on March 25th of 2019. This case challenges the ATF's effort to rewrite a federal statute in a way to bar and punish the possession of bump stocks. In FPC's brief in support of Mr. Cargill, we argue that Chevron deference is neither a standard nor a tool of interpretation. Instead, it is a description of presumed congressional delegation of legislative decision-making authority to an agency and a framework for evaluating the consequences of such presumed delegation. FPC argues that the court does not need to defer to the ATF's interpretation where there is an applicable canon of a construction that can assist the court in removing confusion or at least resolving confusion from the law in question. That canon would be the rule of lenity. Under the rule of lenity, when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a manner that is most favorable to the individual. Since this issue involves a criminal penalty, if the court believes there is ambiguity in the definition of machine gun, then it should resolve that confusion in favor of the individual, here Mr. Cargill, not the ATF. Finally, FPC argued that Chevron deference is completely inapplicable in issues involving interpretation of newly created crimes. The ATF cannot be allowed to 1. Create criminal laws through interpretation of vague statutes, 2. Then enforce its own newly created law, and then 3. Receive judicial deference from the courts in such actions. Instead, FPC requested in the brief that the court remand the case back to the lower court with instructions that it review the plain meaning of the term machine gun, and if it finds ambiguity in the term, to then resolve that ambiguity by applying the rule of lenity, not Chevron deference. This brief was filed and co-authored by FPC's Director of Constitutional Studies, Joseph Greenlee, George A. Moskery from the University of Wyoming College of Law, and Cody Wisniewski from Mountain State Legal Foundation. The brief is available for you to read at fpclegal.org. Don't forget we have our own bump stock lawsuit, the first one filed, currently on appeal at the District of Columbia Circuit. You can see all of those filings at bumpstockcase.com. So if you agree that the ATF cannot arbitrarily redefine the definition of machine gun and then charge you with a crime under their new law, head on over to joinfpc.org and join us in the fight against these infringements and other similar infringements. Your donations go directly to helping our team file cases and briefs of this nature. Once again, this is Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.